Okay, folks, let's get started. In this video topic, I'm going to talk about the interaction between the typical bar regulation of lawyers who solicit clients on the one hand, and then the constitutional limits on that regulatory power on the other hand. Those limits mostly come from the First Amendment, such as Free Speech Clause and the Free Association Clause. There are two particular cases that define our most important two data points on this question. Some things are fuzzy, but we do have two pretty important data points to talk through. So I'll talk through these cases. You've read them, and then we'll talk together about applying the principles and figuring out what's left of the unmapped landscape. Let's jump in. The first of the data points that we'll be looking at is the Orlich case, Orlich versus Ohio State Bar. This guy is a piece of work. He's amazing. Albert Ohralik hears about an auto accident 11 days after it happens. He calls the parents of the driver. He knows that the driver is in the hospital and is a young person. So he calls them up and asks, "Can I visit Carol in the hospital?" And the parents say, "Come by here first." So he goes and visits the McClintocks, the family of the driver of the car in the accident. And they say that an uninsured driver hit Carol. They're worried that a passenger named Holbert, somebody they don't really know, just an acquaintance, not really a good friend, they're worried that she might sue them. But Orlich helpfully explains that there's an Ohio guest statute. It means that the passenger can't sue them. So the passenger, if they're going to recover, is going to have to sue the other driver. And Orlich also helpfully suggests you might want to hire a lawyer. They say that Carol, who's 18, is going to decide this. So then Orlich goes to the hospital and directly visits with Carol, who is in traction. This is an amazing scene, right? He's sort of standing over her, and she's in traction, and can she really understand what he's saying? He offers to represent her. He asks her to sign a retainer agreement, but Carol says, "No, I want to talk to my parents first." So he goes away. Tries to find the other passenger in the hospital, but she's already checked out. Then decides, same day, I'll go back and see the parents again. On the way there, he swings by the scene and takes photos. Then he goes back for a second visit at the home of the McClintocks, this time armed with a tape recorder. This is where it really gets unsavory. He's got the tape recorder, obviously, because if they say the magic words, "Yes, you're our lawyer," then he wants some evidence of that, even if they get squirrely about it later and won't sign the paper. Not exactly your lawyer as fiduciary, holding things in trust for the client. So he goes back to the home with his tape recorder running. He examines the insurance policy. And says, "Oh, there's an uninsured motorist clause here. That means there are benefits of $12,500, both for Carol and for Wanda. Great news." Our saga continues 2 days later as Orlich returns to the hospital to visit once again with Carol and get her signature. She has called her parents in the meantime and said, "Yeah, let's go with this lawyer, Orlich, who's so helpfully showing up and pestering us both at home and in the hospital." So he shows up to get her signature. She agrees to the representation, and then he goes to visit Wanda. He gets Wanda's address from the parents, saying, "I want to talk to her as a witness." He really wants to sign her up as a client. So he goes, talks to Wanda, gives her a little tip about the insurance policy. That is, there's an uninsured motorist clause. You can recover here. He says, "I will represent you. What do you say?" And eventually he badgers her into saying, "Okay." Later on, Wanda's mother tries to repudiate this agreement, says, "No, we're going with some other lawyer, not with this guy." And at first, Orlich says, "No, your agreement is binding, you can't get out of it." But later he files for withdrawal of the representation. But when it comes to Carol, she ultimately decides to replace Orlich with another lawyer, but Orlich is having none of that, and when she does recover, he sues her for his portion of the fee, the contingency arrangement in the original contract. So you can guess in this situation what the state bar has to say. The state bar found after a hearing that Orlich violated their rules, but these rules prohibit solicitation of this sort, and so the state bar recommended a public reprimand. The state Supreme Court of Ohio has to hear appeals from this body, and they hear the appeal and affirm the disciplinary outcome, but they up the ante on the remedy, and they say suspension, indefinite suspension is what you will receive for this violation of the solicitation rules. So the question is, what's the U.S. Supreme Court going to do when Orlich challenges this discipline and says, no, you can't do this as a bar because that conflicts with First Amendment rights of various sorts, including commercial free speech and possibly free association. Given these facts, do you have any doubt how this is going to come out in the U.S. Supreme Court? They affirm the discipline and say, yes, the bar has authority to reach conduct like Albert Orlich's. Really, you could have gotten Orlich on any number of provisions, not just the solicitation provisions, but lying to clients and to non-clients, and you've got various violations here. The Supreme Court does try to say that the bar's authority to regulate attorney efforts to find clients can go so far as to regulate solicitation, but it can't prohibit all advertising. So it says solicitation is different from advertising. It's different because solicitation is in person, and that creates more pressure on the potential client. It demands an immediate response, unlike seeing an ad and you can think about it in your own time. If somebody says, what do you say? Can I represent you? The clock is ticking and you feel some pressure to respond right away. There's also a one-sided presentation. Rather than being able to look across several different ads at your leisure, you're hearing from one possible provider of legal services. So it's a one-sided presentation. And the court says the client is injured and distressed and might place trust in a lawyer who is, quote, a professional trained in the art of persuasion, and might do that regardless of the lawyer's qualifications. Now notice, Orlich did some things that are allowed under the solicitation rules. So if he had only provided free advice about the uninsured motorist clause and the presence of a guest statute in Ohio, truthful, accurate legal information offered to these prospective clients, if you just are offering general information of that sort, no problem under the solicitation rules of the bar. Where you get into trouble is when you take the extra step and actually ask for the attorney-client relationship, essentially asking for money. So you can do everything other than ask for the contract. Could you say, you need a lawyer, pregnant pause, look meaningfully at the client or the prospective client, but don't say, and I could be that lawyer. It is a tenuous line that the court is dealing with where bar regulation is concerned here. Justice Marshall has some reservations about all this. He notes that, the bar is normally the sort of upper crust fancy lawyers, and they're normally coming down on their lower class competitive brethren and always casting them as the bad guys, money grubbers seeking out clients, but they are approaching people who need legal representation. They're hustling in a sense, but they're also broadening access to legal, to the courts and to the legal system. So he believes that the solicitation rules ought to be read in a way that puts meaningful information in the hands of possible consumers. And so they should be read to protect at least some solicitation. Now, he has no trouble with disciplining Orlich here, and so he's concurring in the result, but he is concerned about a kind of class distinction within the bar and about access to justice for people who depend on this kind of solicitation for some of their important legal information. Now here's our second data point, and this one is about Edna Primus, who is in a slightly different situation. She's working in private practice but works pro bono for the ACLU of South Carolina, and she meets with women who were sterilized in the state as a condition of receiving their welfare payments. And she suggests to these women in meetings that they might want to
pursue possible litigation against the doctors who performed the sterilization and get some kind of money damages. Now, after one of these meetings, Primus writes a letter to a woman she knows was present, somebody who had signed up on the sign-up sheet, and says that I want to remind you about that meeting that you attended and just want to know, do you want to file a lawsuit? And if so, I can come visit you and talk about it in a few days. Well, Williams, this prospective client, takes the letter with her to the doctor and says, "Doctor, I got this letter. What do you think of this?" And the doctor says, "I don't think very much of this at all." Turns it over to lawyers for the state and for him, and they file a disciplinary complaint against Primus for solicitation. The South Carolina Board of Commissions on Grievances and Discipline says that Primus did violate the solicitation rules, and they recommend a private reprimand. She appeals. On appeal, the South Carolina Supreme Court affirms, but then ups the punishment to public reprimand. And then she appeals to the U.S. Supreme Court. And here the U.S. Supreme Court says you can't enforce the bar regulations this way because it infringes on the First Amendment free association rights of both Primus and potential clients. And so the bar has overextended its authority. It has conflicted with constitutional rights here. Now, how is Edna Primus different from Albert Orlich? That's the key question, because we're dealing here with two data points, right? We know that the bar can go so far as to regulate Albert Orlich. It can discipline him for what he did, but it can't go so far as to regulate and to discipline Edna Primus. So we know that the outer limit of the bar's enforcement authority lies somewhere in between Orlich and Primus. As for where exactly that falls, this is part of the common law process, and we figure it out along the way. But you might note that that Primus wrote a letter. It wasn't an in-person solicitation, so that might matter. Arguably, it was not for pecuniary gain. Probably not. The court really stresses the lack of pecuniary motive of Primus here. She's volunteering for the ACLU. The client wouldn't be charged attorney's fees, so there's another possible difference in the Primus case. And for Primus, the lawyers at the ACLU would have taken no share of the attorney's fees awarded by the court. At any rate, we do have two data points on just how far the bar's regulatory authority goes to prohibit or to stop at least some forms of solicitation. So we'll practice with these when we get together next.